Good. Well, I think we'll make a start. Good afternoon or good morning, good evening, everybody, and a warm welcome to our webinar. My name is Claire Cameron. I'm one of the directors here at Public Administration International. PAI, as you may know, is a London-based international consultancy and training organisation specialising in governance worldwide. And our webinar today is looking at the need for law reform. And I'm delighted that we have, firstly, Michael Sayers here, who's Acting General Secretary of the Commonwealth Association of Law Reform Agencies. And Michael's also, for many years, been our workshop director for our own international workshop on law reform. And then we have three very distinguished, experienced speakers for you. I won't say too much about those colleagues yet, but you can see their names and countries. South Africa, Malawi, and Trinidad and Tobago displayed. And Michael will be chairing and hosting the seminar. So Michael will be introducing each of our speakers as we go along. So I think the best plan for me is to be very brief because we've got a lot to get through. And I'll hand now to Amanda, my colleague, who's just going to talk us through how the webinar software works and a few other related things. And then I will rejoin you at the end to say thank you and to wrap up. So over to you now, please, then, Amanda.
Thank you very much, Claire. So good morning or good afternoon to everyone, and welcome to this law reform webinar. I'm just going to go through some very quick admin points with you all. On the left-hand side of the screen, you will see several boxes. We have a questions box, a poll box, a chat box, and the handout box. We will be launching polls throughout the webinar, so we do ask that everybody participate with that. Questions, if you have questions for Michael or for any of our guest speakers, please use the question box to type those questions to us, and we will be going through a question and answer session at the end of the webinar. Please do use the chat box to talk amongst yourselves and to talk to us, the trainers. We'll be monitoring that throughout. For the handouts box, you will, at the end of the session, receive the slide deck, a recorded copy of the webinar, some reading materials and links to our PAI website. If anybody has any technical questions, please do use the chat box, and myself and my colleague Denise Smart will be responding to that. If you do have any questions regarding the webinar itself, please do use the question box. Michael, I shall hand this over to you now.
Right, you are. Thank you very
Okay.
much. Am I on? I'm nearly on.
You're nearly there.
Accepted. All right, everybody. Thank you very much, all of you, for coming, and a very warm welcome. Some of you from faraway time zones, we welcome you all. I see there are some good number of people have registered, a really encouraging number have registered. I know that not every one of them will manage to make it, or some may be a bit late. I see that there are many law reform friends I have amongst you, and a wide variety of participants. Some of you are very familiar with working in special law reform agencies, but many of you have not had that experience, and we'll try to make this session really meaning for all of you, however brilliantly knowledgeable you are, or however far down the other end of the extreme. We're concentrating on the continuing need for law reform in every country, and also on some of the key hallmarks that we see in successful law reform, doing it well and successfully, and also on law reform during and after this fearful pandemic, which all countries have suffered and are suffering. And I very much hope that none of you or your families or friends or colleagues have been suffering. Our main speakers have very different backgrounds, experience, and they have really rather impressive CVs, which I will not run through completely, but I will summarize a little later. They will speak quite briefly so that there is plenty of time for you to take part, using the chat box and asking questions, making comments, disagreeing with us, agreeing with us, and all the rest of it. We shall mainly take those questions and various points after the three main speakers have finished, but we reserve the right to barge in at any stage. We expect the webinar to last about an hour or an hour and a quarter. So I think feel that we're ready to proceed. Just a few words about our first speaker, who's Rosemary Kumitsonyo.
Sorry, Michael, I'm just going to interrupt you there. We're just waiting for Rosemary to come back. So perhaps if we can start with Jody.
Okay. All right. I'll move to Jody in that case. Our second speaker is Judge Jody Kollapen, who's the chair of the South African Law Reform Commission. There's a lot of whispering going on in the background. We'll ignore that. He practiced as an attorney in Pretoria for many years in South Africa, particularly focusing on public interest litigation. He joined the South African Human Rights Commission as a commissioner in the mid-1990s and was appointed chairperson of that from 2002 to 2009. And he then served as vice chairperson of the South African Law Reform Commission. From 2013, became chairperson a little later, and he is a judge of the High Court in Pretoria and has acted as Justice of South Africa's Constitutional Court. So if you are ready, Jody, to take first place instead of second place, I'm going to hand over to you.
Thank you, Michael. I am ready. I was going to have a cup of tea and a sandwich, but I'll defer that to later. Okay. Right. I've taken over, and yes, thank you firstly for the invitation from PAI, facilitated by Michael, for me to participate in this important webinar during these difficult times. And the topic I'm going to speak to is the hallmarks of successful law reform. It would have followed Rosemary's presentation with why the need for law reform, but I imagine from my presentation, the need for law reform, even though that's not the primary focus of my presentation, will emerge. And as I start, it may be useful to go back almost 200 years to a speech made by Lord Brougham to the English Parliament on the 7th of February 1828, encapsulating, as it were, what successful law reform is all about. I'll just quote about one paragraph from that speech, although I must say that speech lasted all of 6.5 hours. I don't intend to be so long, and Michael will not allow that in any case. And let me quote what he said, and I quote, "It was the boast of Augustus that he found Rome of brick and left it of marble. But how much nobler will be our sovereign's boast when he shall have to say that he found the law dear and left it cheap. He found it sealed in a book and left it a living letter. He found it the patrimony of the rich and left it the inheritance of the poor. He found it the two-edged sword of craft and oppression and left it the staff of honesty and the shield of innocence." From that quote, and I imagine all of the participants...
Sorry, Jody, I'm just going to interrupt you there very quickly. Can you switch your camera on? And also, don't forget to move your slides.
Okay, I'm not going to use the slide, Amanda, so not to worry about that. Okay,
thank you.
Is that better? Good, thank you. Okay, so from that quote, it's quite clear that even then, as it is now, that law plays a central role in our societies, in our democratic dispensations, and the idea of the rule of law encapsulating within it the notion of a rules-based society or a law-based society, or in the context of my own country, a society where the constitution is regarded as the supreme law of the land, elevates the law to a very critical role in just not the architecture of our societies, but its very DNA, the structure of our government and its relationship with its people, the distribution of power in that structure, the relationship between state and citizen, the relationship between citizen and citizen, how public goods are to be distributed, how we moderate the exercise of power, both public power and private power, how we put in systems of checks and balances, and how we ensure that rights are created with concomitant responsibilities. So the law plays center place in all our lives, and therefore we all have a stake in that law, and therefore law reform is so very, very important if one views it against that context. It's not simply a technical exercise, but an exercise that goes to the very heart of who we are and how we live and how we exist and coexist. But implicit in all of that is this notion of what may be regarded as a healthy tension when one engages in law reform and when one examines what would be the hallmarks of successful law reform. And that tension means simply that what is regarded as success may differ depending what your vantage point is and where you're located in society. So consumer protection laws may throw up different notions of success depending whether you're a bank or a supplier of goods or whether you're a consumer. And in that context, for example, how one balances contractual freedom and the freedom of parties to engage freely in contracts, with, on the other hand, guarding against the excesses of contractual freedom and protecting the rights of consumers. And there are many such examples in laws that may be developed to deal with the media. How does one advance the idea of an open society while at the same time recognizing that dignity and individual autonomy and reputation are equally important values that warrant protection? Similarly, in the area of administrative law, how does one ensure the efficacy of government while, on the other hand, ensuring fair and just decision-making processes? And these are all imperatives that stand often in tension to each other, and successful law reform needs to be mindful of those. But successful law reform also needs to understand the very DNA of that society. What is the context of that society, the social, the economic, the political, the cultural, the religious? What are the values of that society, and how are those values to be ascertained? In a constitutional dispensation like ours, we've been able to put those values into our constitution. But in many other societies, those values have evolved over time, and law reform must be mindful of those values and alert to those values. The next issue is, what is the transformation trajectory of your society? How do you balance, in a sense, certainty that is located within the status quo and the unpredictability that may come from transformation that is both necessary and warranted and important in any society, particularly one like mine that comes from a shameful history of oppression and discrimination? And so in all of this, the idea of what is successful law reform is not an easy one. It's a loaded concept, but nevertheless, it's one that must be located, I think, in a nuanced and in a sophisticated understanding of the various powers that are to play in that society, the interest groups, and very often the imbalance in power. And one must guard against the notion that those with influence and with access to the media and with the ability to change hearts and minds do not play an undue influence in influencing the trajectory of law reform. And that's very important for law reform agencies. And so with that background and almost with an indicator of what would constitute successful law reform, let me just deal with three small topics that go to the heart of what is successful law reform. The one would be how one chooses the project of a commission if you have a law reform commission in your country, given that very often law reform commissions are small and under-resourced, and that the demand is often far greater than its capacity and its ability to respond to the demand. So the choice of projects can't be arbitrary. It has to at least have some logical sequence to it, and it enhance the legitimacy of the institution in its ability to defend why it took on a particular project and why it didn't take on another project. And some of the criteria that could be useful would be to ask, firstly, is there a gap that needs to be addressed? If there is a gap that needs to be addressed, how is it best addressed? Is it addressed through law reform, or is it addressed through policy formulation, or is it simply addressed to ensure the greater efficacy of existing law? Because very often existing law may well be sufficient, but it's simply not applied correctly. And the last thing one wants to do is embark on an expensive and long-term exercise in law reform where the law is adequate, but its implementation is inadequate. And so the suitability of law reform is an important factor in determining how one chooses an investigation. Then, just as important is the resources and the funding available. Critically important is, given that ultimately whether law reform proposals result in legislation would depend on the departmental support and the necessary political support for that area of the law to be reformed. And if that is lacking, then law reform is unlikely to be successful in the sense of it being implemented. And so these are all critical factors that need to be considered. Some may, in the context of a given investigation, weigh heavily than others, but it's really a mixture that goes into the melting pot and for that determination to be made. And it's important for the public and others to know what the criteria is that a commission follows, and so that they can at least be satisfied that the criteria was applied, even if the decision at the end of the day was an unfavorable one to a particular request. So much so for the criteria. Michael, you'll just remind me of my time. Thank you. The second issue is around process. And I simply make the point that very often process is just as important as outcome, because you could have a law that's technically astute, that's capable of being implemented, and that complies with the best international practice and standard. But if the process that accompanied the making of that law wasn't one that was participatory, that involved the public in consultation, involved other stakeholders, then the outcome of that process becomes delegitimized, and the best outcome then doesn't really matter. And therefore, certainly, law reforms across the world have committed to the principle of adequate consultation, transparency, and openness in their work and in all stages of the process, from the beginning of an investigation, when the issue paper goes out seeking responses to initial questions, to the discussion paper that contains draft proposals, and to the final report that contains the final product of the commission. The process of public participation and consultation is absolutely vital. And in that process, the process is predicated on questions rather than answers. So the inquiry always starts with questions. It can never start with an answer, because if it starts with an answer, with respect, it's doomed from the outset, because it says to the public out there, the Commission has already taken a view on this issue. So it starts with the question to ensure that the process is legitimate, to demonstrate that the Commission has an open mind that is willing to consider and listen to all submissions and to give equal attention to all of them, as opposed to starting with a question. But let me not confuse questions with principles. And so just by way of example, if one is embarking on a project that looks in the penal system, I don't think the principle of equality is one that is to be negotiated. It must be a non-negotiable and a given. What is up for negotiation and for consideration is how the principle of equality is converted into effective law that strikes the balance between the rights of prisoners and those on the outside, the need for incarceration as opposed to the recognition of their rights. But you don't violate the principle of equality. And that's where there's a difference between a restatement of principle and then the asking of questions, so that the end product is never preempted, or there's never an indication that the Commission has already decided. That's also important for the independence of the Commission, that it can be seen to be not simply doing government's bidding or the bidding of some big lobby group, but that it would start with an investigation with an open mind, unsure of what the outcome would be, and guided by the submissions it receives, its fidelity to the principles of law and the values of that society in coming to its ultimate conclusion. And so the process, I can't emphasize more, is critical. Just then finally, two other brief comments is, one is that, as indicated, these institutions are small and very often under-resourced. And the expertise required in undertaking credible and effective law reform is considerable. You may need to look at cyber law, and there would be no one in the Commission who has any experience or expertise in that area. And so commissions across the world, including ours, have developed systems. We call ours an advisory committee, where for each investigation, we would appoint probably the best experts in the country. They don't have decision-making power, but they would advise and guide the Commission. They would be able to critique the submissions and the recommendations we receive from third parties so that the Commission takes a balanced and objective view. But also they send out an important message to the community out there that even though the Commission is small, it is supported in this investigation by people who are credible and are well known as experts in that field. And that enhances public confidence, just not in the institution, but in its ability to undertake any particular investigation, in particular those that require particular technical expertise. So the system of experts works quite well. Certainly for us, our difficulty is to ensure that we don't allow the experts to substitute our judgment and our decisions at the end of the day for theirs. And that could be quite an interesting tension, but generally it's a healthy tension. And I think in this regard, let me just then move on to the last stage of the process, and that's the final product. Ultimately, one wants a product that is capable of being implemented. And very often one looks at matters statistically in terms of assessing the success of a commission or the success of a law reform project. What percentage of your proposals resulted in it might be contentious to use that as a yardstick of measurement, but ultimately you embark on law reform because there's a perceived need to reform the law. And if the law is to be reformed, it must result ultimately in legislation passed by Parliament. And so there must be a connection between that. You just don't do law reform for the sake of undertaking fascinating research into a particular area of law. And so increasingly, in terms of the end product, there's a greater demand to show practicability, to show cost efficiency, to show that the law can be enforced and there's enough resources. And in South Africa, we have a socioeconomic assessment tool that would subject the product of law reform to various indicators to see whether it's cost effective, the administration can support it, it's capable of being enforced. And ultimately, that throws up particular tensions. And two of those is the tension between timelines in law reform, where very often law reform agencies would say that we need more time because law reform requires careful, serious reflection, deep drilling down, sufficient time for consultation and proper consideration of all views. And government may have a different view. It may say, well, look, the exigencies that exist in our society require us to put in place a law on gender-based violence or on domestic life partnerships sooner rather than later. And I think there's merit in both. And there's an obvious and ongoing tension between the two, which can only be reconciled and managed through ongoing dialogue. And ultimately, successful law reform must mean that the government is able to implement it and has the political will. And therefore, the closeness between a law reform agency and government is something that one must recognize on the one hand in that process, but also guard against that from eroding, as it were, the independence of the institution in coming up with proposals that are credible and that are done with the necessary level of integrity. And so, Michael, I think I'm almost at the end. And what I simply want to say is that in any given investigation, the variables may change. The nature of the public consultation may change, but those indicators that I've highlighted, I think, remain constant. The intensity with which you focus on one as against the other may differ in different processes, but ultimately, good law reform is about good institutional behavior, good process, and a good outcome that generally sits comfortably with the DNA and the values of your society. So let me stop there. And I'm not sure if I've exceeded my 10 minutes. Probably not.
Not so sure about that.
Okay. Before we actually leave you, Jody, I'm just going to launch a poll question for our audience to respond to. So if everyone would like to cast their vote, and towards the end of the webinar, I will show the results to everyone.
Thank you.
Amanda.
Hi, Michael. Hi, Michael. I'll just switch over to you now.
Right. Right. Thank you, Amanda. Thank you very, very much, Jody. That was, I won't say anything about the timetable, but it was marvelous to combine at rather high level thinking, which I think will have caught some people unawares after lunch in this jurisdiction anyway, with the practicalities of how to go about the business. And I expect to see quite a few questions and chat remarks appearing in the relevant boxes. So a big thank you to you for first of all, for that. I like to think that everybody's doing their voting. We had to decide which particular things might be the biggest challenges, and there could have been any number of others. Just give you a moment or two to think about that while asking Amanda if Rosemary's available or not.
Rosemary is available, Michael.
Okay, I'll just introduce her in that case, which I started, I think. Good to have you with us, Rosemary. Rosemary is the Law Commissioner, or head, if you like, of the Malawi Law Commission, that lovely country in the middle of Africa, and has been for a couple of years now. She was once in private practice in a law firm in Malawi and managing partner for 15 years. So you're beginning, participants, to get a feel for her background, rather different from the one that Jody Kollapen had. Then she was in Malawi government as chief state advocate, and then director of public prosecutions for Malawi. Then as deputy head of mission for Malawi at the Malawi embassy in Japan. Not that number of law commissioners or law reformers have done that sort of thing. And now she's ready to speak with us back to the subject of why on earth do we have to bother about law reform? What's the need for it? Rosemary, is all yours.
Thanks, Michael. I'll just switch over to Rosemary now.
Hello, good afternoon.
Hi, Rosemary. Hi.
Hi, Claire. Oh, is that Claire or Amanda?
It's Amanda, not to worry.
And Claire. Hello,
Hi,
Rose.
Amanda.
Welcome. That's super. Glad you could join us this time. So over to you.
Sorry about that. Good afternoon, everybody. I'm going to speak on why is law reform needed. Why is law reform needed? The law is vital, and improving the law is constantly vital. Many changes are taking place across the world, which lead to a need for the law to be kept up to date and modern, and as simple, relevant, and cost-effective as possible. The ever-growing complexities of life, they make the need for law reform. For example, gender-based violence, sometimes known as domestic violence, it causes more deaths and disability among women aged between 15 to 44 across the world than cancer, malaria, traffic accidents, and war. Hence the need for law reform. The world is so complex. The increasing range of the rule of law, for example, democratization, good governance, and public participation. These are also all means of why we need law reform. In Malawi, for example, in 1974, we changed our old constitution to a new one to meet the needs of democratization. Increasing pressures on many, including on individuals and on governments, for example, to respect human rights and human dignity. This is all the more reason why we need law reform. For example, when in the new constitution of Malawi, the 1974 one, they made provision of the Malawi Human Rights Commission as an institution, and it is entrenched. It's a constitutional requirement that in Malawi we should have this organ of state and this governance organ, and this is to help people meet the needs to help check government on the rule of law and respect for human rights. And then there's also scientific and technological change, ranging from communications to computers to DNA to end-of-life issues. This is all the more reason why we need law reform. And then the increasing life expectancy and the aging and the accompanying problems of an aging society. We need reforms for these to meet those needs. And then we also have health issues, for example. The amazing advances, for example, in vaccinations and other medications and transplants. And also, how about the scourges like HIV and AIDS, drug addiction, alcohol abuse, and mental illness. And now we have the coronavirus. How do we deal with that? I remember when, this is the recent phenomenon. There was an outcry in Malawi as to if we were going to put up the lockdown. If the government was trying to introduce a lockdown, for example, there's an outcry to say there's no law that meets this, and yet currently the Law Commission of Malawi is actually reviewing the Public Health Act, which is going to take care of these new, for example, the coronavirus issue and many other issues. We're just about to finish reviewing that act. And then there's the issues like population growth, the continuing divide between the rich and the poor, both between nations and within nations, all these complexities. This is all the more reason why we need law reform. And then there's also the issue of globalization, touching areas as diverse as trade and commercial life, international exploitation, whether human trafficking, corruption, sex trade, child abuse, or sex tourism, and the ever-growing interdependence between countries and within countries. In Malawi, for example, the Law Commission recently reviewed on the trade exploitation, sex exploitation. So there was the report on the Trafficking Persons Act, which is new. It has just been passed, but this is to take care of all these sex trade, trafficking. You see, Malawi has porous borders, and the porous borders were being used by the sex traffickers, the human traffickers. You see, to traffic, to pass through their neighbors, passing through Tanzania, the neighboring countries like Zambia to South Africa. So the Trafficking in Persons Act is trying to meet that need, to address that need. And then there's also the issue of climate change and the environment, including global warming, water shortages, disposal of nuclear waste, dumping and deforestation. How are we going to deal with all these things? That's the more reason why we need the law reform. It's so hot in Malawi at the moment. It was extremely cold just a few months ago, and now it's scorching. How do we take care of these environmental changes? And then there's also the matter of urbanization, for example. Changes in family patterns and community life. Changes in family patterns. For example, the Malawi Law Commission did actually do a review on the abortion laws. And at the moment, the report on the Termination of Pregnancy Act, which is an abortion law, is going to go through Parliament shortly. And now people are lobbying, and there's public debate on abortion laws in Malawi. So we can see that these are the changes, family patterns. It was taboo in Malawi a few years ago to talk about abortion, but now there you go. People want to have a say in it. So that's changes in family patterns and community life. And then there are changes in the political, religious, and social beliefs and attitudes. In fact, the Termination of Pregnancy Act, it touches on religious and social beliefs. So you hear diverse views between the religious and those and other social norms. But even within the religious, there are also others that are for and others that are against termination of pregnancy. And then you have changes in politics, in political act. We have an example in Malawi of the electoral laws. In 2018, I mean, the Law Commission had a report on the electoral laws to change, for example, the majority rule on how a party can win. And the commission had proposed the 50+1 majority rule. When the report went to Parliament in 2018 rejected it. It rejected the 50+1 rule. But then last year, when we went to the polls for the presidential elections, the law, that was in May 2019, the law was first past the post. But then the elections were challenged in court. And what did the court say? They passed the law to make it 50+1. So these are the issues, the changes in the political arena. Now it is 50+1, but it has to go through Parliament as well. The ever increasing dangers from weapons, their numbers and destructiveness. This is also another area for the need for law reform. The growth of extremism, huge financial problems and pressures in the world. These are also, that's another area. And then we have I can also give examples, world examples. For example, the key areas of worldwide, each of which needs law reform. For example, over half of the citizens of the Commonwealth are under 25 years of age. A vast range of legal issues can arise, from child abuse to youth crime, and from child abduction to the care of the vulnerable. For example, even in Malawi during the COVID-19 lockdown, schools were closed. There's been an upsurge of teenage pregnancies. How do we take care of this? And then there's the increasing life expectancy and aging and the accompanying problems that I talked about here. The number of people in the world with dementia, for example, is 35 million people have dementia. And the forecast to be in 2050 is going to be 120 million. How are the crucial decisions about medical treatment, money, and other assets, and where they live to be made for each of them individually? These are issues that have to be looked at in law reform. And then we have the gender-based violence, sometimes known as domestic violence, which causes more death and disability among women aged between 15 to 44 across the world, rather than cancer, malaria, traffic accidents, and war. How do we take care of this? There's about 8.8 million women in the Commonwealth who are married as children every year, and in Africa, that is a huge issue. How do we take care of that? What laws do we put in place to assist to curb this? And then also widely, there's the scientific and technological change ranging from communications, as I've already said, to computers, and from DNA to end-of-life issues. And then there's another example of increasing pressure to respect human rights and human dignity. That pressure is huge. And in Malawi, the issues are there. The more and more people want their rights respected. And then there's also delays in justice. The Chief Justice of one country with a population of about 20 to 30 million people said that his country had a backlog of 1 million court cases. This is all over the world, a backlog of cases. Currently, the Malawi Law Commission is reviewing the Supreme Court Act, and we are hoping that will also take these issues, and also we have an intended program to look at the judicial service so that we can take care of all these matters. I hope you can hear me.
We can hear you, Rosemary. We can't see you at the moment, though.
I guess that's fine. Let me see. Yes, thank you. Sorry. And then there's updating of court systems for dealing with disputes, e.g. virtual. For example, now with the coronavirus, with the COVID-19, how are the courts dealing with the matters? Are they virtual? I know at the Malawi Law Commission, for example, we've been holding our meetings virtually, I think during the COVID-19, but at the courts, it's a dilemma at the moment with legal houses. How do we deal with the court system? So we need law reform in all these areas. Globalization affecting trade, I've already spoken about that. And then there's bribery and corruption. The equivalent of about $1 trillion is paid in bribes worldwide every year. Even SDGs on substantially reduce corruption and bribery in all their forms. In Malawi, we have an institution called the ACB, Anti-Corruption Bureau, which was introduced in our constitution as a governance body to take care of corruption. But there are more emerging issues, more new ways of corruption. How do you deal with that? And then I think I've already talked about climate change and the environment, including water strategies. There are many examples that we can give to take care of law reform and where reform is needed. Thank you very much.
Thank you, Rosemary. Michael, I'll just launch a poll question.
Michael.
Thank you, Rosemary. Not that you can hear me.
Yes, I can, Michael.
Oh, good. Excellent.
Okay, what I'll do, Michael, is I will switch over to you. The poll question has been launched and people are responding. I will just transfer back to you.
Yep. Right, thank you. Thanks ever so much, Rosemary. Lots of masses of examples, and including some really interesting and good ones from Malawi and other places too. Incidentally, listeners and audience participants, I think all the slides you've already been told will be made available to you, and that includes Jody's, who you may have cottoned onto are in the pack of slides. He didn't actually need to use them, but they're rather good slides too, as are all the slides, I think, that the three speakers have produced. Now is a good time for you to think of questions to put on the in the questions box when you've voted in the poll. Do feel you can ask questions of either Jody or Rosemary, or indeed any of us, and you can ask them at any time you like. So you just put in a short question there, and between us we'll see how many of them we can answer. Some can be to all of us, particular one of the speakers. So do feel very free to do that. Don't feel that you know too little about the subject, or for that matter, too much about the subject. Just pile in there and ask questions, or make comments. Say that you don't agree with something or other, or why on earth does such and such happen? Anything you like to ask, and we'll do our best to, between us, to answer. So I think time is definitely marching on. I do keep an eye on the time, but it's a bit difficult for me to intervene and say to one of these lovely speakers, hey, it's time to stop. But our last speaker is from a very different part of the world and different place, and she's done very well to be here at this time. And I congratulate also all you Australians, Canadians, and all the rest of it who have made real efforts to stay up really late or to get up really early to be with us. The last speaker is Paula Cross-Horton, who's worked for 17 years for the Law Reform. That's quite a contrast to Rosemary. She is Senior Legal Research Officer there and concentrates on policy development in complex matters. She took her law degree at the University of London and a master's in legislative drafting at the University of the West Indies, which is a well-known place for doing legislative drafting, amongst other things. So, Paula, we look forward to hearing from you.
Hey, participants, I am waiting for the slides to appear.
Over to you.
Okay. Screen share. Live. I'm not familiar. Broadcast. And where am I?
You okay there, Paula?
I'm trying to actually access the slides. All right. Okay, here I am.
Perfect.
And I'm going to put on my camera.
Perfect.
Hello, everybody.
Hi.
Good morning, world. It is my pleasure to be part of this esteemed panel as we discuss the need for law reform throughout the world. I have, as part of my presentation, been asked to deliver the issue of law reform during and after COVID-19. So it's a very unfortunate subject, but law reform is definitely needed here. We all acknowledge that the pandemic adversely affects the way in which we live and has caused social and economic harm in many countries. But we must also admit that it's an opportunity for our governments to establish concerted efforts to put in place the UN development goals and also to establish appropriate rules for our present reality. Amidst this pandemic, there is a clear evidence that governments have imparted varying forms of regulatory, various ways in which they are regulating the COVID situation. But what is the role of law reform in the midst of all of this? In the slides which follow, I will briefly discuss three relevant matters. One, the possible issues for consideration by law reformers such as myself, the impact of the pandemic on the practice of law reform, and the possibilities for law reform after all this ends. Okay. As social engineers, law reform institutions identify the contemporary issues that may require legislative or executive regulation. As regards COVID-19, law reformers may have to research and analyze domestic and international laws, PAHO and WHO guidelines, sociocultural, economic, and socio-legal studies, with a view to proposing the modernization or introduction of rules to curtail the spread of the disease among local populations, to address the legal consequences arising from the measures to prevent the spread, and to address the legal consequences from contraction of the disease, and unfortunately, where death arises. To be specific, law reformers could advise governments of various measures and legal issues revolving around matters such as restrictions on individual movement and interaction with others, mandatory or voluntary use of face coverings, and the implementation of the COVID vaccine programs, as well as access to public spaces during a pandemic. In the case of my commission, the government of Trinidad and Tobago received and acted upon our advice to temporarily limit public mobility and interaction through a provision in the existing public health ordinance. Though the ordinance is dated, it proved adaptive to the COVID situation as it evolved in my country. The government has also requested our advice with respect to the use of face coverings and the cremation of bodies of COVID-19 victims. At this time, we as law reformers should bear in mind the UN objectives for sustainable development. Important is a goal to promote the rule of law, the rule of law, justice and peace. Thus, law reformers may be able to examine and advise on matters such as the noticeably sharp rise of domestic violence and human trafficking cases, which the two speakers before elaborated upon. Here in Trinidad, we saw an increase from 232 cases in 2019 to 558 cases in 2020. The Commission here in Trinidad and other bodies recognize that our Domestic Violence Act may require in-depth analysis to determine whether the violence cases the rise in these cases rise in legislative framework for victims to seek justice or enforcement by the administrators of the Act. Law reformers may also provide expertise on matters pertaining to the administration of justice, on matters such as bail, access to legal representation, and access to the courts. As law reform is traditionally an avenue for the modernization of the law, law reformers should examine existing laws governing property rights, access to housing, and ability to engage in financial dealings. For example, should the law enable alternative means to witness wills rather than in person in light of the quarantine measures? In some countries, law reformers may have to review the efficacy of ordinary powers of attorney compared to modern forms such as the enduring and perpetual powers of attorney. Indeed, that is the case in Trinidad and Tobago. We also see the need to reform its laws relating to housing. Our rent restriction laws have long lapsed. Should we revisit those laws? I know in Tasmania, evictions activity during the pandemic has stopped. Is that an issue for law reform? Then there is the business of death and death care. The funeral services industry is a largely unregulated one throughout the world, but COVID has caused many policymakers and persons in the industry to call for reform, and that has been the case here in Trinidad. Should funeral homes be self-regulated or state-regulated? And what is their role in providing services to the state when we have mass deaths? Then there is the obvious issue of education. And that is a subject of the Sustainable Development Goal number 4. Do our laws adequately ensure equity in the delivery and receipt of education? What are the factors which impede education, and how may the law attend to this issue in the future? So what is the impact of the disease on law reform? We see that it affects many agencies in their daily operations, the application of the law reform methodology, and the execution of law reform programs. Sorry, just trying to move the slides here. So with respect to the operations of law reform agencies, we see that like many other institutions, the Law Reform Commission in Trinidad is subject to the public health ordinance regulations relating to COVID. Like departments such as the DPP's department, the Solicitor General's department, we are experiencing or have experienced curtailed or non-existent in-person meetings. This is replaced by an adaptive management approach with work at home rules and reporting rules for staff. We are seeing slow record management of our official files, which we keep here at the offices of the Law Commission. Officers have working files, and we have to work 2 days in, 2 days out. So it's definitely an impact there. We have also closed our offices during the mandatory lockdown. With regard to the law reform methodology, I have to say that our ability to practice law reform has not stopped, but it is otherwise affected by certain factors which you see on the screen. We have a restricted ability to conduct research at physical libraries. We must now rely on online and socio-legal research databases. We must take an adaptive approach to public consultations. So instead of going to the community to hold meetings or direct meetings with stakeholders, we conduct virtual consultations. And we are hoping to conduct online polls where we put forward our law reform questions to the public. We are hoping for our public to be more sophisticated in responding to the consultations in that format. Then there is the maintenance of networking relationships. Our Law Reform Commission has close relationships with our Trinidad and Tobago Police Service, with departments within the Ministry of Legal Affairs and the Office of the Attorney General, and within other departments within the state. But then there are the NGOs, and there's the man on the street who is directly affected by what we are proposing. Lastly is the timeline for the delivery of policy recommendations and draft legislation, as well as the execution of law reform programs that had existed at the time when the COVID situation became a pandemic. I wish to impress that what I've said so far may not be universal in terms of the impact on law reform bodies throughout. Both speakers as before have spoken to the fact that law reform agencies tend to be small, but we have differences with respect to our size and human resource expertise. So for example, in the Law Reform Commission here, we do not have specialist committees to deal with certain topic areas, as opposed to other law commissions which have those committees. So that affects the output of the Law Reform Commission. Usually there is a small team or one person working on a law reform topic, depending on the complexity of the matter. Then there's the type of law reform agency model that is being used. Our Law Reform Commission was established by an act of Parliament, so we are a statutory body, and we operate under the aegis of the Ministry of the Attorney General. But then there are institutes, there are government departments, so you have to look at the relationship. And that brings me to the next point. There are differing administrative arrangements within and with government. And if you are to look at the Commonwealth Association text called Changing the Law, which is an excellent text for law reformers, you will see examples such as in New Zealand, where the Law Commission there has a direct relationship with the cabinet. Then there's the issue, a never-ending issue of funding and resource allocation. In Trinidad, we do suffer from that. It is within recent times have we been able to have all officers, or at least most officers, improve their professional development through access to the LLM programs. But then there are other areas of law which we seek funding for. For example, having an in-house editing team, an in-house IT team to create a web page, which is non-existent. And then there is the never-ending issue of ensuring that we have enough officers to complete the projects. And lastly, public exposure via the internet, which affects many law commissions. if you do not have sufficient public exposure through public education exercises, an online presence, a social media presence, it makes the public wonder in our case, well, what is the Law Reform Commission? Is there a Law Reform Commission? So what about the possibilities coming to the end, at the end of COVID? Well, as I have told Michael before, I don't have a seeing eye. However, we do note that law reform methodology will continue. We are very confident of that. It is going to continue to assist society in modernizing the development of the law as it adapts to the implications of the pandemic, networking with stakeholders with common objectives, assisting governments in developing a framework of action in the event that another disease, another dire event impairs our society. And lastly, what is very important is that governments should consider the establishment of dedicated institutions. If it is the institute model, the statutory model, a departmental model of law reform, which can provide the most effective means for the practice of law reform. And for the 60 permanent law reform commissions or bodies that exist, we may have to rethink our way of work. We should revise our existing laws to improve the organizational and infrastructural provisions to make us more effective as law reform commissions. And I provide with you there an example of one law reform act, that is the act establishing the Law Reform Commission of Trinidad. I know Barbados has just joined us, the Cayman Islands, Jamaica has a law reform department. So within the Caribbean region, we see law reform actually taking a serious hold. And I would like to end my presentation with a reference to the tailored review of the Law Commission of England and Wales report. This was done in 2019 by the Ministry of Justice in the UK, where they recognize that the Law Commission there is imperative and essential and vital. It reiterated the role of the Commission in improving access to justice by making law more accessible and transparent. So hopefully we can look to the Law Commission there in England and Wales as an example, as a beacon of light for all of us in the world of law reform, as we deal with COVID-19, as we help the governments in dealing with it through law and moving forward. Thank you very much. And at the conclusion of this slide, you will see that I have certain references to materials such as domestic violence, WHO, as well as Carlos's text that you can look to. All right, and have a good one, everyone.
Many thanks, Paula. I'm just going to launch a poll question for everyone to take part in. So I'm just going to launch that now. Michael, I'll just hand over to you.
Thank you. Right. Thank you very much, Paula. Very well done. And some marvelous slides too. Slightly frightening ones, one or two, but marvelous standard. And thank you for all you said. I haven't looked to see, and I don't see any questions from anyone. Well, I'm not sure if that's because you're all completely flummoxed or fast asleep, or every question you might have asked has already been answered. But do feel free to do so. We've still got a few minutes if we wish. the poll questions that I'm sure will be told in a short while by Amanda the outcome. But I would like to say a big thank you to all the three speakers for all the work. You can imagine, many of you, how much work goes into one of these webinars, actually. You might not imagine it, but it actually is quite a bit. And it's only for an hour and a quarter or something like that. But they've put in excellent and helpful presentations. And I think that's been really helpful. And of course, it will linger on into the future because we'll all have access to it after today. I'll take my opportunity while giving thanks to thank PAI too for taking up the idea for this webinar and for all the arrangements and absolutely essential assistance. They don't pay me for saying what I'm about to say, but I usually do say it, and that is, if ever you need a consultancy or a training workshop or something like that in the subject matter that they deal with, I do commend them to you. They're a very small organization, but they're excellent, and they do look after you if you're helping them in the sort of role I have. They don't pay a fortune, but they pay, and that's perfectly all right. So I think that's probably everything I wanted to say at this stage, except perhaps I think I probably can go on to mention something else, which I think comes up on another slide, and I'm not quite sure how to get to it.
We've actually had two questions come through.
Oh, they've come in. Good, please.
Yes.
I'll have a look.
So the first question is from Richard Percival, and he's basically asking if he would be interested in the views of the speakers on how to consult with difficult to reach audiences, particularly those unrepresented by organisations. So perhaps that's one for our speaker.
Yeah, absolutely.
Comment?
Any of you three like to respond on this? Can they still hear me?
They should all still be able to hear you.
Any volunteers?
I'm here, Michael. I'm here, Michael. Oh, sorry, Joe.
Let's have Paula, and then Jody.
Okay. We have had that experience here in Trinidad. What can happen is, as we did in the past, is when we prepare papers, they would be printed by the government printer and placed at strategic locations at public places such as post offices, and, courts, and so for persons to collect and read. So it depends upon your population, of course. Do you have a reading population in the traditional sense? Then in this new era of, I shouldn't say new, it ages me. In this era of technology, you can use your online presence, and which I spoke to before. Unfortunately for us in the Law Commission, we don't have an online presence. But when you look at examples such as the England and Wales, Australia Law Commission, the law commissions out of the provinces and institutes in Canada, you would see that they would place their papers online and invite submissions. So that is one way in which is another way in which you may want to target a population. Then there is a very traditional way where again, depending on resources, you may want to collaborate with your Attorney General's office or Department of Justice to seek funding to go out into the community. So you use advertisements to highlight the fact that you are conducting research or consultation on this particular matter, and you would invite persons to come to public meetings at halls, and so for them to air their issues. Of course, you have to be able to put forward information which they can then provide a constructive response. But that could be worked out. I hope my submission helps.
Thank you very much, Paula. Jody, did you like to add to that?
Very briefly, Michael, I'd support what Paula says, and I think one of the difficulties is that in an unequal society, those who can read and who have access to technology are much easier able to access the work of the commission and to respond to that, and also to make those responses public. But it's the difficult to reach audiences like Richard Percival asks in his question, and how does one reach them? And I think that's where a commission has to be proactive, in particular where those audiences have a real stake in the subject of the law reform investigation being undertaken. And public consultation, in a sense of actually going into those communities and convening a public meeting and explaining what the investigation is about and soliciting people's views, become absolutely important. It's fraught with all kinds of difficulties. As we find, sometimes you go in to consult on a particular law reform proposal, but that community hasn't seen anybody from government or anywhere for years. And they offload, in a sense, all of their difficulties on you. But it's important because you're there to listen as well. And sometimes you can simply act as a conduit. So I think that level of consultation, even though it's costly and it's time consuming, is important ultimately to ensure a balanced approach and ensure the integrity and the legitimacy of an institution like a law reform commission. Yeah, thank you.
Thank